Okay, I believe everybody is in. Good morning. Welcome from LCBR to all of our association friends. First thing, I just want to thank DRE Director Marcia Waters for taking time to join us today. And let's go through a couple of quick housekeeping items before we begin. If the settings work correctly, and it looks like it did, everyone should have been muted as they came into the meeting, and we ask that you remain muted during the discussion when you are not speaking. If you want to use chat to post questions, that'd be great. We will try to get to as many of those as possible after Marcia Waters concludes her presentation. If you do want to ask a question via voice, we will save a little time for Q&A at the end as well. Just raise your virtual hand so we can call on you. There are a lot of changes that have happened this week and last, and there are more coming at the end of September. So our ask of Director Waters was just to take a little time and discuss what she believes are the most important changes that are coming our way. So without any further delay, I'll give Director Waters the floor. Thanks again for joining us.
Well, thanks for having me. Good morning, everybody. So there has been a lot going on, largely due to the legislative session this year. We had a sunset bill, and this follows up a year of them reviewing our real estate commissions program. That bill went through the legislature this year. There was a Department of Law bill that changed a couple of our statutes as well. We've had rulemaking, and we've also done forms. So I thought I would start off with just kind of giving you guys an overview of forms. We ended up modifying 39 forms, I think, total. 22 of those do not have substantive changes. It was just adding intellectual property language on the forms itself. This is something that we started doing last year. These are the commission's intellectual property, and we want to preserve the rights. So we don't want somebody to take one of our contracts, use it in another state, and pass the Colorado contract off as their own, which has happened before. So 22 of the forms, we just simply put the intellectual property language on it. The other forms, though, did have substantive changes. We are working through finalizing those, and once we get them finalized, we will get them posted to the website so that you all can see the changes in advance of them going into effect on January 1st. But a couple of them that I want to point out for you, like the brokerage disclosure forms, are going to look different. We kind of took the consumer's perspective into account to try to better explain to the consumer what the different relationships entail and what the duties are. So those forms are going to look different. At the commission meeting last week, the Real Estate Commission asked us to do one of those brokerage disclosure forms without the compensation language on it. So we will have that available, but there will also be the form that has the compensation language available. And you can use that when you go out and show properties, particularly those of you that are realtors or use realtor-owned MLSs. The brokerage disclosure to buyer form still kind of meets that NAR threshold of having that compensation agreement in place. When you're showing property, the change with the law, which I'll go into in a little bit, you're going to have a listing contract before you perform any license duties. Showings, hosting open houses, doing CMAs, those are not license duties. So you don't have to have a listing contract to do that. And I know that this is contrary to some of the information that CAR has put out in their legal bites, but I want to remind you, CAR is not the regulator. They do not hold you accountable for the license law. And one of the things that I want to show you later on when I get to the Department of Law bill, because one of the other pieces of misinformation is that the AG's office is going to start enforcing whether you have listing contracts in place. That is completely inaccurate. So I will show you in the law when something is a violation of Consumer Protection Act versus when it's not. And you can see that in the Department of Law bill when I show that to you. So the brokerage disclosure forms are going to look different. We have updated the listing contracts because prior to the legislative change, you had to have informed consent from your client to be able to share any of their confidential information. That was changed due to an amendment run by CAR on our sunset bill to express written consent. We've asked our counsel, who's the Attorney General's office, for some legal advice about what express written consent is, because to use their terms, this has created a Frankenstein. This is not like a standard of consent that really kind of exists in law. If you Google it, you might find express written consent in the regulations for telemarketers from the Federal Communications Commission, but that's about it. So we are asking the AGs for some guidance for us, just to know what we need to look for during the course of an investigation. But it is like express written consent is not kind of a regular standard of consent in the law. And then there's the post-closing occupancy agreement, which we've modified that because there was also a bill run to basically exempt the security deposit requirements for post-occupancy agreements. And this was House Bill 26-54. So prior to this bill passing, you couldn't collect a security deposit if you weren't collecting rent. And the max that you could collect was 2 times the rent amount. So if the rent amount's zero, security deposit amount was zero. So they've exempted that. You can now, with a post-closing occupancy agreement, you can collect a security deposit if you're not collecting rent. I would be careful about the amount of the security deposit you collect, because if it is something that is just astronomical, I would expect that you might see the Department of Law run legislation to put some parameters around what those security deposits could be. So those are kind of the big forms changes. Just keep an eye out. We usually get them posted to the website the first part of October. And then you guys can kind of work through the changes. We'll have the red lines and also the clean versions up for you. So the law changes that we had to deal with were the sunset bill to continue the Real Estate Commission and the Division of Real Estate. That was House Bill 26-1287. So to give you kind of a brief summary of what a sunset review is, when you've got a regulatory program, periodically, and it's in statute, they will go through and do a sunset review of the agency to see if regulation is still necessary. And once they clear the hurdle of answering that question, if there's any modifications that need to be made to the Practice Act, are there antiquated statutes? Have there been changes that need to be incorporated into it? Are there efficiencies that could result from a statutory change? There's 14 different criteria that they evaluate our programs on when they do a sunset review. I was not afraid that they were going to come back and say that real estate brokers could self-regulate and that we didn't need to do it anymore. Based on our complaints, there's no way they would have come back with that. But what they did do is they did make a series of recommendations. The division is in a position to be a stakeholder, just like everybody else is during this process. So we submit recommendations. The realtors submitted recommendations. You may have recommendations coming from the general public. Licensees who are not part of a trade association can provide suggestions. They go through and analyze the program. They issue a report on October 15th, and that has their recommendations in it. Once that report is issued, then when the legislature convenes, that report goes in front of our committee of reference, and that committee decides whether they're going to pull a bill title and run the bill, which they did. And then it goes through kind of that open legislative process where anything can happen to it once it's been introduced. And there were some CAR amendments that were made to our bill. They changed informed consent to the express written consent standard. They took away the commission's authority to audit the funds that come into a real estate broker's possession that are unrelated to license duties. And they also made a modification to the affiliated business arrangement statute so that with affiliated business arrangements, when you disclose those, you only have to disclose them to the party that you represent, and you only have to make that disclosure at the time of referral. So I think the big takeaways that you guys need to know from the sunset bill is one of the things that the division had requested was that we be able to inactivate a license when somebody has not complied with their continuing education requirements. Mainly from the perspective of when they completely ignore the real estate commission when they've been selected for a CE audit. So we were given that authority through the sunset bill, and we're also able to charge a fee for continuing education course approvals. But with the CE audits, so if you're notified of a CE audit and you don't respond, we will typically make multiple attempts to get a hold of you. But after the third or fourth attempt, we're done trying. And prior to this bill going into effect, what would happen is we would then have to refer that case over to the Attorney General's office, and they would have to take it to hearing, which is expensive, and your license fees fund our activities. We don't want to litigate CE noncompliance cases, particularly when somebody chooses not to participate. So we would rather inactivate your license and deal with you when you want to go active. So that is what's going to happen. So please, if you get notice of a continuing education audit, please respond, because if you don't, we will inactivate your license. With the course approval portion, the reason that we'd asked for that was, again, your license fees fund our activities. We spend a lot of time approving courses for continuing education credit for educators, who then turn around and some of them charge you a fee, some of them don't. But we felt that the educators should be paying for our services to review those. I don't anticipate that it's going to be a very high fee. We are doing fee setting next week. So CE classes, I anticipate, although I'm not certain yet because we haven't done the fee setting, it should be in the ballpark range of $25 per course. So that's the big thing with the sunset bill that I wanted you guys to be aware of. With the Department of Law, I want to share my screen with you because there's been some misinformation put out about these changes. So, okay. So this is what the Department of Law bill looks like. Let's see if I can get rid of that sidebar. So when a law gets passed, this is what it looks like. And this is a big bill. It covered a lot of different things. A lot of it had to do with the Consumer Protection Act, but it also touched on our licensing statutes for real estate brokers. It also touched on DPO's statutes as well. So we're going to go to 58, page 58, because that's where our part starts. So you have this 1210-403, and this is a law that it's already existed. The strike through is what is being eliminated, and then the caps are what's being added to the statute. So this was the statute that said that if you were a single agent, you had to have a written agreement with the broker or the parties to be represented by the broker. It has been modified to now say that you have to either establish a transaction broker or a single agency relationship in a written agreement with the parties. It has to be established before you perform any of the activities described in 1210-201-6A. 1210-201-6A, that's the list of what requires a real estate broker's license. And to put it simply, a broker's license is required when you bring two parties together and you're negotiating the terms of a transaction. But I would tell you to look at 1210-201-6A and also look at the statutes mandating the type of relationship that you have, whether it's transaction broker or single agency. So doing a showing or hosting an open house, doing a CMA, those do not fall under 1210-201-6A. Those are not licensed duties. You don't have to have a license to show property. And to give you kind of a real world example, a lot of brokers have personal assistants that may go out and show properties. They don't have to be licensed to do so. You can also have an unlicensed person host an open house for you. Some of the information that has been coming out recently is that this now falls under the Department of Law's authority under the Consumer Protection Act. That's not accurate. And I want to show you the difference between how this statute looks, and then we go down to the next one. So 1210-403.5, broker engagement contracts, this was passed, I believe, in 2023. This was to address the whole MV Realty business model, where they were ensnaring consumers into 40-year listing contracts, and you couldn't get out unless you paid them basically what they felt their commission would be. So when something does fall under the jurisdiction of the Attorney General's office, along with the real estate commissions, and that it can be considered a violation of their Consumer Protection Act, that's when you start seeing this language about Section 2 of this section commits an unfair or deceptive trade practice as provided in Section 6-1-1051 RRRR. That is the language that then pulls it also under the AG's authority. So if you notice, the one above does not have that language. This is still strictly within the Real Estate Commission's jurisdiction. So with broker engagement contracts, all they did was update the section citation, because earlier on in this particular bill, they made a bunch of modifications to the Consumer Protection Act. Then the next change for the real estate brokers under this Department of Law bill is 1210-408.5, non-commission approved contracts to buy and sell. So this is somewhat consistent with Rule 7.5, although because now this is in law, we repealed 7.5 last week. And I will go over kind of the rule requirements after we get done with the law. But when you are representing a consumer in a transaction where a principal is using their contract, and it may be a home builder, a bank, or a buyer, you have to advise that consumer to seek legal advice from a licensed attorney before the consumer enters into the purchase contract. So if you're the buyer's broker and they want to buy from a home builder, before they sign that contract, you need to tell them to seek legal counsel from an attorney. It goes on, and this is a little weird how they put this in here. If a broker contract includes a unilateral cancellation clause in favor of the broker, that provision must be clearly and conspicuously disclosed to the consumer. About the only time that I can think that you would have a broker contract is maybe when you're using a listing contract, because with a listing contract, a broker is one of the principals, although we would encourage you to use the commission approved form if it is applicable. So those are the ones that you need to be aware of with this bill, is just when you're dealing with home builders, banks, or buyers that want to use their own purchase contract, or sellers that want to use their own purchase contract, you've got to make that disclosure that they need to advise an attorney. And then the big one is you have to have a listing agreement. Now, this concept of if the consumer doesn't want to sign it, you can be their transaction broker, it doesn't exist anymore as of August 12th. And these were modifications made. The Department of Law actually issued a 2026 legislative report, and I believe it was recommendation 9 of their report. This is to basically codify some of the NAR settlement requirements, which is interesting because if you look at the NAR settlement, there's a 7-year timeline for these requirements. But this is now in law. We don't have another sunset review to provide kind of a broader review of our statutes for another 11 years. So they had at one point, before this bill was introduced, they had wanted to make showing property a license duty, and the division dug its heels in and said, no, that's not okay. You've got unlicensed personal assistants that show property. Having unlicensed people show properties is pretty prevalent with property management as well. And then just for sale by owners, if I wanted to sell my house on my own, but maybe I wasn't available and I asked my neighbor to show my property, my neighbor shouldn't have to become licensed. There's no skills necessary to unlock a door and let somebody in the property. So we had said that if they were going to start making showings a licensed activity, that would increase the number of people that we would have to regulate, which would cause a fiscal impact to the division. And given the state's budget issues, pieces of legislation with fiscal impacts just are not going to make it through the legislature. So they decided to take that out, which I'm glad, because I don't view the NAR settlement as being really consumer friendly. It doesn't give consumers a chance to really vet their real estate brokers. Additionally, you guys don't get a really good chance to vet the consumers. If they just want to go see a house, they just want to go see a house. It doesn't mean you should be bound by a contract right out of the gate. And I know when I was a practicing licensee, my managing broker was like, life is too short to be in a deal with somebody that you hate. We are not seeing that these days. We get a lot of calls where the relationship has become completely acrimonious, but the broker refuses to let the consumer out of the contract. And I'm concerned that because of the way the NAR settlement came about, the frequency of that situation happening is going to become more of an issue for us to have to deal with than it was previously. So that's the Department of Law bill. Okay. I'm trying to figure out how to stop sharing my screen. I don't usually share during Zoom. Laura, any tips?
If you go down to share, it should.
Oh, I closed the window. Okay. So because of the law changes, we knew that we had to update some of the commission's regulations. And in that process, we decided just to kind of do a quick rule review to take a look at the regulations in general. When we engage in rulemaking, we have to follow the Administrative Procedures Act, which is a state law. And you'll hear us call it the APA. So the APA mandates that no rule should be adopted unless, number one, the record of the rulemaking proceeding demonstrates the need for the regulation. Two, the proper statutory authority exists for the regulation. And an example of this is like if the commission woke up one day and said, we want to regulate home stagers, let's adopt a rule to do that. They don't have the authority to adopt that rule. So the APA wouldn't allow for that. Three, to the extent practicable, the regulation is clearly and simply stated so that its meaning will be understood by any party required to comply with the regulation. So we need to look at these for plain language. Four, the regulation does not conflict with any of the provisions of law. And lastly, the duplication or overlapping of regulations has to be explained by the agency proposing the rule. So when we did our mini rule review of the rules, there were a lot of rules that restated statute. That's not the purpose of a rule. And we really want our licensees to not just look at rules, but you also need to be looking at the statutes. Because at the end of the day, the statutes are the ones that are really the foundation. The rules just kind of provide the walls and the roof and the floor to the foundation. So there was a lot of statute duplication. We had rules that were inconsistent with statutes. And then we had a lot of rules that were just kind of written ambiguously, not very clear for you guys. So we cleaned up the language, and that is most of what happened with the rules last week, was a lot of cleanup. But there are a couple rules that I want you to be aware of. So 4.6B, that clarifies that applications for continuing education course approvals require the payment of a fee. I don't know how many of you offer classes, but this will be something that will come into play for you September 30th when these rules go into effect. 4.8 is a new rule about continuing education. This rule memorializes that the commission has the authority to audit brokers for CE compliance. And it also establishes that a license will be inactivated if a broker fails to respond to a continuing education audit. It also tells you what you have to do in order to come back once you've been inactivated. 5.11 was repealed. This was the statute that basically explained the accounting standards for funds coming into your possession for non-real estate related activities. And then 6.5B, this is an existing rule. So 6.5B said such activities that do not include preliminary conversations or small talk concerning location and property styles, and it said, or price range when responding to general factual questions from a potential consumer concerning properties which have been advertised for sale or lease. The price range raises some concerns because it could take you down the road of getting confidential information before you have established any sort of brokerage relationship with a consumer. So we took out price range and in turn, we replaced it with market conditions or property prices. That way, you are just discussing factual data about either the individual property or the neighborhood that it's in or the broader market. It's not going to hopefully lead you down the path of asking somebody, well, how much do you qualify for? Why are you looking to move? Those are types of questions that fall under the confidential information within the Brokerage Relationship Act. And then 7.5 was the rule about basically those principal contracts. We repealed it due to House Bill 14 or 26-14-26. The Real Estate Commission also looked at several position statements last week. Most of them were updated just to either deal with removing informed consent and replacing it with this express written consent standard, or updating other aspects that change because of the laws. The one that I want to flag for you is CP 26. This was previously titled Reducing the Buyer Pool. We have changed the title to Creating Barriers to Access because what was included in that position statement last week addresses private listing networks, and the different considerations that need to be factored in when you're doing a private listing network. They have pros and cons for both sellers and buyers. And so with a seller, you need to make sure if you're doing a private listing network and that's how you're going to market the seller's property, they need to be aware that they are not going to be exposed to the open market, which means that they may not get the highest, best offer possible. And I think there's been studies that show that when you have pocket listings or private listing networks, the seller does not benefit from those. They actually end up with a lower sales price than they would have, and the property stays on the market longer. From the buyer's perspective, if a buyer is only being shown properties within one brokerage firm, they may not be exposed to a property that really fits their needs. Additionally, there are fair housing concerns because you could be steering them to a particular neighborhood. So you need to be really cautious and careful when you are dealing with private listing networks. If we get a complaint against a broker about a private listing network, we're going to start asking questions of the consumer about what exactly did they understand with the use of that type of marketing plan. So the position statements were all adopted last week. There were a couple that were repealed just due to the informed consent issue. Those have all been finalized and they are up on our website now. So you're able to look at those. The rules will be up here soon. We'll have a clean version up on the website. Once the Real Estate Commission adopts rules, we have to submit the updated versions to the Secretary of State. There's an Attorney General review to make sure that we are staying within our limitations of the law for adopting rules. And once the AG opinion says everything's good, then the finalized version is made available, but the rules will go into effect on September 30th. I was going to give you guys some population numbers really quick, and then also let you know what we're hearing as far as complaint trends. And then I'm happy to answer any questions. So with population numbers, as of the beginning of this month, we have 49,448 real estate brokers in Colorado. If you do a look back from a year ago we had 50,556. So there's been a little bit of a dip in the population. With appraisers, we have 2,745 appraisers. A year ago, we had 2,915. So a slightly bigger dip for them just because they're such a small population. Mortgage loan originators, we have 21,610. A year ago, we had 19,616. So their numbers are going up. With complaints, I don't oversee investigations anymore. So I'd ask my deputy what she's been seeing. We are seeing an uptick in brokers that are filing complaints against other brokers. They file them for contract errors, not disclosing the brokerage firm in advertising, errors in MLS listings, and then not responding or being difficult to reach. And there's a there's an overlap between broker filed complaints and consumer filed complaints. So with public complaints about brokers, we see number one is poor communication. Number two is being difficult to reach. Three, clients having to remind brokers about contract deadlines. Four is failing to disclose conflicts of interest. And then the last one is really concerning. It's brokers trying to be dual agents. So you cannot, dual agency went by the wayside a long, long time ago, like 32 years ago. So, and I verified, I was like, are you talking about actual dual agency or people trying to be like transaction brokers? And she said, no, people trying to be dual agents. You cannot be a single agent for both sides. You can't be a single agent for one side and a transaction broker for the other side. So just be very cautious with your brokerage relationships because that will trip you up. And if we find somebody doing dual agency, that's when we start calling you unworthy and incompetent. And I don't think anybody likes to be called that. So that's kind of my presentation. Do you guys have any questions for me?
If anybody does have a question, feel free to raise your hand. Otherwise, Laura, if you have one.
I do. I was hoping, thank you again, Director Waters. I was hoping you could clarify a bit on with transaction brokerage, how that would work with the timing of getting those signed, because there's definitely some misinformation about whether property can be shown and when we need to get those signed. So if you could just kind of clarify that for us, I think that would help a lot.
So if you're just showing the property, you can do the brokerage relationship or brokerage disclosure to buyer. And for the realtors, you would use the one with the compensation language to meet the standards of the NAR settlement. That's just putting them on notice of these are the brokerage relationships available and that currently they don't have a brokerage relationship with you. And we're making some clarification to the language and the compensation agreement too, that is not a listing contract and the compensation language is not sufficient to establish a brokerage relationship. So when they start wanting to discuss confidential information or you want to start asking them confidential information, they want you to submit an offer, that's when you're going to need to have that listing contract in place. You're going to have to establish a brokerage relationship because they're giving you confidential information and you're going to start representing them. So that's when the listing contract needs to come into play.
And just to clarify, is the division going to be looking at the date on when those were signed in relation to, say a contract to buy? Are we wanting to make sure that those are, done ahead of time, or how's that going to be treated?
So you want to have the listing contract in place before you do the contract to buy and sell. And we do look at the dates. So it's not necessarily going to be if they're both signed on August 14th, I don't think that's going to raise any eyebrows for us. But if the contract to buy and sell is dated August 14th and you don't have a listing contract until August 20th, then that's a violation of the license law essentially, because you've started providing brokerage services to them, brokerage duties, without having that listing contract in place.
Okay.
And this is a big change and we recognize that. So I don't necessarily think that every time we come across one of these situations where a broker may not be aware of the law change and they make this mistake, I think we will go through a period of trying to educate people rather than the hammer of enforcement.
Okay. And then I have one more question that I see we have some in the chat as well. So I see this periodically, like on Facebook or whatever, where people want to sell as FSBO. And they'll say at the bottom, no realtors, please. I already have a contracting realtor if we decide to get help with that. And so obviously there's some realtor that has said, don't worry, I'll help you and treat them as a customer. Is that still going to fly?
So you have to establish a brokerage relationship with one of the parties. You can't just be like this really helpful real estate broker that has no relationship with either of the principals to the transaction. That's not how brokerage relationships work. Additionally, you've got to be really careful because real estate brokers can't charge just a fee to do contract documents. This is part of the whole Conway Bogue issue. You have to perform your license duties, and part of your license duties allow you to complete those standard forms. So if you start just offering your services as, I charge $250 to review contracts or help you do contracts, chances are you're going to get yourself in trouble with the real estate commission because you're not establishing a brokerage relationship and performing those duties. Depending on how bad of a job you are doing with that, though, the real estate commission can discipline you, and then they can refer you over to the Supreme Court or attorney regulation for the unauthorized practice of law. So, plus the whole thing about the FSBO saying no realtors, please. Well, the buyer is entitled to be represented. So if they want to reduce their buyer pool significantly, they can say no realtors, but there's going to be an issue for those buyers that want to have representation.
Thank you.
We
All
have one
right.
in chat that
All right.
says,
Read that
we do
for
have one in
us.
chat. I'll just ask. The current brokerage disclosure form with the compensation language has 2 places to sign, and the additional pages look like an add-on. Will the new disclosure form be more intentional and flow with the compensation included? So just one signature is needed.
No, it's still, the compensation is still further down at the bottom of the document, separate from the actual disclosure. So we haven't streamlined that part yet. Maybe the next time when we look at that form.
And a follow-up that I think came up at a previous session on the brokerage disclosure forms themselves entirely. None of those will work as the same way a listing contract would for transaction brokerage.
Yeah,
Correct?
no, they are not. Those forms, even with the compensation, that is not the same as a listing contract.
If anybody else has one, throw it up. And I'm seeing no more questions.
All right. I'm also seeing no questions. All right. Well, if anyone has any, feel free to email us. Director Waters, thank you so much for your time today. We really appreciate it. And yeah, we'll see you guys next time. Does
Well,
anybody
thanks
have
for having me.
any announcements?